Morning. Were you? It's called.
Oh, seminars. I just go to seminars. And then that part of teaching.
Morning. Good morning, everybody. Morning. How are you?
I can't see them at all.
Oh, it's gonna come.
Just listening.
Yeah.
Yeah, and people online see okay the screen?
I just see you.
Oh,
I see you.
right. So I haven't shared it yet. That's a good point.
Good point.
Okay, good to go.
Okay, sounds good. You see the screen okay?
Yes.
No idea. Oh, because they're only seeing that. I don't know. I can unpin it, see if that changes anything. Well, anyway, I think they can see okay.
Yeah, we're good.
Okay.
Okay. Okay. All right. Hi, everyone. So my name's Edward. I'm one of the partners at Property Light. Some of you have already know me. Some of you don't. So, I pretty much handle primarily a lot of the purchase and sales in the office. Also, we also do a lot of commercial stuff as well, but main idea is residential purchase and sales. We also have a team called Refi Law that does a lot of refinances as well. And it's more of like a simplistic refinance type of transaction. So we're one of the largest residential real estate law firms in Canada. We also have an operation out in BC and Alberta. So if you have clients moving out to Alberta, for example, we can also do like the deal here. Let's say they're selling here and buying there, or vice versa. We find a lot of people at the moment are coming back rather than going there. So we're doing a lot of deals where people are actually coming back to Ontario versus going to Alberta. So that's kind of interesting to see because I always thought it was the opposite. But maybe last year was like that, and then this year kind of for some reason has shifted. So I'm going to kind of go through some common closing problems that we're seeing a lot lately. I presented this last year, I think, but I've amended it a little bit. Some things have changed since last year. I also have a really great example of a situation that I thought would never happen in this current market, and it just happened to me last month. So I thought I'd put that in as one of the examples because I've used it before, but I've used it in a different type of market. So I kind of wanted to explain that and see how there's maybe potentially like a shift happening out in the market. So common closing problems that we find that really affect deals that from closing either on time or just closing entirely is things like buyer beware. So buyer beware is a scenario where every buyer goes into a property with this idea of buyer beware, meaning that they have to do their own due diligence on the property. They don't just get to you don't buy a used home and then all of a sudden expect it to be brand new. Right? So like if there's a hole in the roof and you didn't do a home inspection, well, then that's too bad for you. You should have done a home inspection to figure out there's a hole in the roof. So, talking about inspections and conditional clauses for financing and whatnot are very important right now with buyers and making them go through those stages because there are situations where they think they can get financing, but it turns out they actually can't get financing that they thought they can get, and it's a lot less than they are going to get. So it's important to kind of give them the opportunity to go and do a financing inspection, a home inspection, because what they do is they come back and point finger at you as agents, right? So those are big ones, buyer beware. And property typically has to be in the same condition as when you sign the agreement purchase and sale. So for example, a seller has a positive obligation at that point to make sure they continue to maintain the home in its current state when you first signed the sale agreement. So if something breaks during the next month or 60 days or whatever the closing period is, the seller has to go and fix and repair it. So like, for example, we had a client the other day that, not the other day, but like, I forgot when there was like a lot of rain and it was warmer weather and everything was like melting and stuff. It's like 2 weeks ago, I feel. We had a seller client of ours reach out to us and say, hey, like, our basement or bathroom or something was flooding. There was water coming in from somewhere and they realized where it was coming in. And I said to them, the deposit obligation on the seller is to first notify the buyer that this is happening, to give them an opportunity to go in and do their own inspection of whatever the damages are, so that they can then potentially hire their own contractor to give them a quote or their own contractor to go in and look at it, engineer, whatever the case is. So the case law, this isn't like a statute written somewhere. It's case law that basically says that if something is substantially damaged in some way, and materially damaged is hard to kind of define that, but it's important to avoid any conflicts or potential litigation in the future to allow a buyer to go in and see what's happened. Like, something happened, something got damaged, flooding, whatever. Let them go in and look at it. And then give them the opportunity to do their own inspections if they want to, rather than potentially then using it against you on closing. That's what happened to us. The sellers didn't go out and let the buyers know that there's this major flooding in the basement. It was like an inch of water on the floor. And it was coming in from like the window well, essentially. And it was in Toronto. The Toronto houses, they're close together. There's like shared driveways and stuff. So I guess the way the water was, it just kind of puddled in the middle between the two homes, and then it just kind of started flowing into the basement. The buyers essentially refused to close, and then delayed the closing, and they brought forward that argument of, hey, we never got an opportunity to go and do our own inspection. We want to get our own engineer in there to review it and make sure everything's okay, and that there isn't $100,000 of work that needs to be done. It's like 10,000 or 20,000 or whatever the cost is, right? So based on that case law, we have to give them the opportunity to go and do that. And so we agreed to extend the deal an extra month. They came in with their own people afterwards. They did their own inspections. The seller ended up doing whatever was required to get it fixed, and we ended up closing. But that like took an extra month and a bit to get the deal closed, right? So if the seller had given them the opportunity when that did actually happen, because they had to rip the walls back out again. They went in, they started doing the work, and the buyer was like, wait, hey, hold on a second. Like I didn't get a chance to actually like see what's behind the walls. I want to know what's behind the walls. What is causing this water to come in, and make sure that you're actually fixing that problem rather than just masking it with some paint and like drywall, right? So it's very important to kind of let them go in and do those inspections, okay? Because we're seeing that a lot lately. There's like, especially right now, this time of the year, right? When weather starts getting warmer and we've got a lot of snow out, it's going to start melting. There's going to be a lot of damages to basements and roofs leaking and things like that, right? So for the next 2 months, kind of think about that when you've got sellers or buyers generally, and let them go in and do those inspections. So everyone kind of puts this clause in to the agreements. It's got to be in good working order, free and clear on completion, right? So on the day of closing, everything's got to be in good working order, chattels, fixtures, appliances, all that sort of stuff. On completions, kind of, there's a timeline to that. The cases have decided that, like, it's that day, maybe the next day, but you can't come back a week later and be like, the dishwasher doesn't work. So it's very important that your buyer client goes in right away and inspects everything and makes sure everything's working, and then notifies the lawyer right away that something's not working, so that it shows in an email, like the timestamp, the deal closed at 7 o'clock, X, Y, and Z is not working properly, right? And then we go and deal with it at that point. But what's important is that the time has to be done right away, not a week later to tell us, hey, this is broken, right? Because that you almost lose your chances in court to argue anything at that point.
But I would like to
Yeah,
come
yeah.
back to the previous thing. Okay, let's say that the buyer comes, the seller gives opportunity to the buyer to inspect that leaking, whatever the case may be, and he comes with his own inspector and he estimates how much it is. Is the buyer can walk away from the deal at that moment? Let's say if they decide that this is, let's say,
Only way that they can walk away from a deal is if it's something that's materially damaged and it can't be repaired by the seller in time for closing. At that point, maybe there's an opportunity for them to walk away. But usually what we do is we try and negotiate some sort of holdback. So for example, like, let's say there was a fire, right? Flood is usually harder to argue to walk away from the deal because it's easy to fix.
Yeah.
It's not difficult to do. But let's say there's a fire. The fire could potentially affect the structure of the building from someone actually living in there and using it. Like, we don't know if this thing's going to fall apart on us because of this fire, whatever the fire is, right? So that's where it's most important to get an engineer to go in and say, this is safe to live in. It's not going to fall down. It's like, you know what I mean? And then at that point, you can sort of argue. It becomes an argument, really. It's not to say that they're not going to use that excuse to walk away. And then it goes to court, and then you decide in court at that point, did they have a right because it was a material affected property, meaning that a human couldn't live in it because an engineer said they can't live in it, right? That's what the case law. Actually, the case law that created this rule was around a fire in a home, where the sellers went and fixed it without letting anybody know. And then they discovered afterwards that there was a fire before closing. And then I don't know who it was, maybe a neighbor didn't let them know, or I don't know. And then they argued that, like, well, we don't know what you did, so we're going to walk away from this deal. And they actually won the case where they were able to walk away from the deal in that scenario.
because the seller pretty much say, okay, I have no money, the insurance will kick on, and it's going to take another 2 months. So then
Yep.
the buyer has to agree that the closing will be 2 months
Yep.
later. But
Yep.
the buyer say, well, I have to live somewhere because I sold my property. There's
And
all kind
that
of-
comes as part of negotiations, right? Between the lawyers, we kind of figure out what one's willing to do or not do, what one's willing to pay or not pay. In that scenario where I had the flood, the clients where we had the flood, we extended because of that reason. The insurance stepped in and dealt with it. It happened a month before the closing. It was a longer closing. I think it was like a 90-day closing. Yep, just bad luck, yeah. And the insurance kicked in and they came in, they did everything they needed to do, and it got repaired. We extended by a month so that the repairs can actually get done by the insurance, and they got done. They actually had to do it a second time because they didn't do a good job at it.
That was my question. What if, like, is there, like, who gets hired to do it? Like, does the buyer have any say, like, who?
Comes back down to the negotiations, like who do you want to do it? Typically a seller wants to do it because they want to know that they're hiring the cheapest contractor they can find, and the buyer also might want to do it or not want to do it because they don't want the hassles of actually, like, hiring contractor. They don't actually own the home yet, so they can't even, like, they can't allow entry into the unit whenever the contractor, because they got to organize it with the seller. So usually it's not the buyer, usually it's the seller that's doing it.
If the seller hires somebody cheap to do it, and then it doesn't get fixed properly.
Yeah, our client ended up having to do it a second time because it wasn't done properly. Yeah, and she paid an extra $9,000 to get the floors redone because they were like, well, yeah. And she agreed. Like, the seller was like, this is ridiculous. Like, I can't believe this contractor did this. I'm probably going to take them to small claims court. And then, ended up hiring a second contractor to fix it. And that's just, like, again, don't always hire the cheapest contractor. I mean, that's just like the general rule. get 3 quotes and usually go with the middle one. But so yeah.
But I'm just thinking.
And also, as realtors, you should also have a book, like a Rolodex of good contractors that you can recommend to your clients, to use, basically.
But then they do inspection after that, yeah, like the buyer.
Yeah, buyer came in, did another inspection to make sure that everything's okay, and did a second inspection after the second work was done, and then ended up closing the deal at that point.
So if your seller had remedied, let's say there was time, 2 months prior, because you started off by saying the property should be in the same condition as from when the purchase is
Signed.
yes is done,
Yeah.
right? Is there a legal obligation still to disclose?
Yes.
Like if,
Yes. Yeah, you should always disclose. Something happens to the home, you should disclose to the buyer. Hey,
even though they brought it back to the standard.
even if they brought it back to standard,
Okay.
because the argument then comes around after the fact where they're like, well, we don't know what the actual damage was. So it could have been a lot more than you're telling me it is. And you don't, as a seller, you don't want to be in a situation where you end up getting sued to try and prove something. Unless you have, I guess you can try and like document it and stuff. But it's always best to let the buyers know what they want to do. I've had clients where the buyers just don't care. They're just like, yeah, okay, cool, let them fix it. They should fix it. And they just like tell them to go. They don't hire a contractor to go and look at it. They don't go and do their own
So it
inspection.
should be same condition from when the APS is signed, subject to any potential damage that occurs in the period of occupancy.
Well, that's the whole point of it. It's got to be in the same condition, because if something changes, you got to make sure you bring it back to its original state. But you should always give the warning to the buyer that something did happen.
So including, let's say that in the meantime, your dishwasher breaks,
Yeah.
and you replace the dishwasher. Should
Yeah.
I inform the buyer that I replace? Okay.
Yep. You should tell them dishwasher broke and we're gonna get you a new one that's
Right.
similar value, similar design. Do you want to buy one yourself? And we'll just credit you, $600 because that's how much I'm willing to pay for a new dishwasher. Maybe they want a new one that's like $1,200 and they're willing to pay the other 600, and know that they're just going to get a $600 credit from you on closing. It's just it's having that open conversation, of I know I'm responsible for this and I'm going to fix this for you, but like, what do you want? Like maybe you want to upgrade it. You want to buy your own, like go for it, but yeah. But so anyway, so on completion, most important part of these type of clauses is on completion. These two words here, on completion, right? Like you got to do it right away, not wait a week later to tell us that something's broken and like then come back. I had clients once, he came and he was like, the floor's all scratched, like 2 weeks later. And I was like, you kidding me, right? Like, how do I know that you're not the one that scratched it by moving all your stuff in? Like, what do you think the sellers are going to say now when I go and tell them this, right? So what do you think a judge is going to look at and be like, well, do you have any proof that it was scratched when you moved in, not after you moved in? So very important on completion. Walk in, house is empty, you haven't moved anything in yet, go around, fiddle with everything, make sure everything's working, and then start moving in, right? Document it too, like photos, videos, like this isn't working, timestamps. And then in good working order, I find this is a weird clause in some ways, because lawyers will argue it for a buyer one way and lawyers will argue it for a seller a different way. And I do this. I'm like guilty of it too. I do it all the time. So basically when we're acting for the buyer, and this is actually the right way to say it, is that the law is that if you bought a home and the dishwasher wasn't working at the time that you bought it, technically, based on the plain language of the clause, you need to give me a good dishwasher on the day of closing. So you got to replace the broken one with the one that's functioning. But on the seller side, as a lawyer, we usually always argue, well, you bought the home in the same, that was the state of the home at the time they bought it, and that's what you get. You don't get a better home. And it's like, well, no, you told me I get a better home because it's supposed to be all in good working order, right? So that the wording of the clause sometimes makes it an argument. This is the one that's always used, and it will be in good working order. All chattels and fixtures are in good working order, right? And like typically, as I think there might be some sort of law about this as well, is that you, as a buyer, can't just go around before you submit the offer, turning on appliances and turn them off, turning on the AC and turn them off, because you could be liable at that point for damages to the home. Like, let's say you turn on the stove and there's a gas leak and it catches fire. Well, you're not liable for that, and you as the agent potentially get dragged into it as well. So like that's why this clause was done this way. It's like we don't know if it's working or not. But we're also not doing a home inspection. That's the caveat, right? There's no home inspection either. You have this representation. Technically speaking, the seller is required to give you all chattels in good working order. But it's always argued that it wasn't working on the day you signed the agreement and you had an opportunity to inspect it and you didn't. So too bad for you. And it becomes this argument on the day of closing that like no one ever wins. And it's usually the seller that walks away because no one's going to refuse to close a deal because a stove's not working, right? Or because one burner on the stove isn't working that costs like $200 to fix, right? Like you're going to close the deal. You're not going to walk away from the deal because of that.
Okay, how about this? We had a situation once some years ago that, okay, you have a home inspection, this property was sold, conditional on inspection, and it was like winter time, and inspector does his due diligence, he does check everything, say, I cannot check air conditioning because
Yeah.
it's winter.
Yeah.
3 months.
But this clause says that it's working, right? It has to be working, right?
This was
But again,
working.
You get to the day of closing and you're arguing over, you're not going to know if the air conditioning unit is working or not, right? So you got to close the deal anyways. And then you find out in the summer, 3 months later, that it's not working, or 4 months later, it's not working properly. And then what do? Your only option at that point is to go back to the seller based on this clause and sue them in small claims court. And you might win.
I just think there's gonna be winners, like, I mean, like 6 months.
Yeah,
after
you're just gonna
this-
have to wait it out. That's the problem. But like no one's gonna go to small claims court for like a $2,000 air conditioning unit. It's a waste of your time, right? We'll talk about small claims court and towards the end.
If, let's say they see 4 months later that the air conditioning is not working and they bring it to the courts, couldn't the courts also say that since you've been living in the house for 4 months, you could be liable for it? Maybe you turn on the air conditioning during that period? At the same
Yeah,
time?
it comes down to evidence and proof and things like that, which is hard. But yeah, they can. That's why it's never good to go to court. Court is like a wild, wild west scenario. You may win, you may not win, you might have the right evidence, you might not have not the right evidence, and like you end up, you don't know. You have no clue going into court, you have no clue if you're gonna win. You can get a judge one day and that says one thing, and a judge, it's like calling the CRA. I don't know if everyone's ever called the CRA. You get an answer one day about something, you get a totally different answer the next day from someone else. It's the same things with court. You have no clue. So that's that. So the idea with these scenarios that I've been talking about is what we end up calling a game of holdback chicken. So lawyers love a good game of holdback chicken on the day of closing, and you have to have a right client that's willing to play the game of holdback chicken. So basically, holdback chicken is who is willing to go to the end and potentially risk a lawsuit versus just agreeing to some sort of holdback amount, right? And we always try and argue some sort of holdback amount to like fix something. So the scenario with the flood that I gave you guys, we tried to close the deal on the day of and hold back $30,000 or $40,000 to let the insurance company do all the work that they need to do after closing, right? Seller didn't want that. They don't want to be involved in renovations. They don't want to have to sit there waiting for contractors to come in, dealing with insurance companies and all that sort of stuff. So they just agreed to allow it to close an extra month later. But usually we try and negotiate some sort of holdback. And some sellers won't agree to it, and some sellers will, and some sellers won't agree to the amount. Like someone wants $40,000, but the seller's like, but it only costs $5,000 to fix this thing. I'll hold back 10. And then the buyer's like, well, I don't know if 10's enough. What if it turns out to be 40? Like we want 40, you know? So like that's and sometimes there's no holdback. Sometimes people they just refuse to hold back entirely. And now it becomes a scenario where either the buyer or the seller has to absorb the cost of whatever the issue is because they want the deal to close. In a balanced market, it's a little easier to deal with. When you're in a buyer's market, usually the buyer wins, and when you're in a seller's market, seller always wins. So, you know, it just depends on the market as well. Right now, I would say we're kind of in a buyer's market with these type of things, with like all the deals, because we're like lagging behind, right? So we're like 2-3 months behind the market usually when we're closing the deals. So yeah, hold back chicken. It's a great one. I love a good game of chicken, and it's you got to have the right client with these things too, that are willing to play the game. Because there's a lot of clients that like are stressed and just want to move in, and they'll do anything to move in. You know, they're like they're being pressured essentially to move in. Big one at the moment that I'm having a lot of issues with is no mortgages, meaning that the mortgage is not approved. It's coming in last minute. We're getting mortgage instructions like the day before closing. It takes us typically 3 business days to process a file. We got to go through the process with asking for money from the lender, meeting with the client, signing the documents, preparing the documents. Like there's a lot that goes into it. So like, we usually say anywhere between 5 or more business days for a deal to close properly without any issues. After 5 days, less than 5 days, we charge a rush fee, and less than 3 days, we charge what's called a miracle closing fee. Because when there's 3 business days left, we're lucky if we close the deal on time and the mortgage comes in at that time. So, but there's a lot of issues there. A lot of issues on appraisals at the moment. They're coming in under values. People are going to have to come up with an extra 50, 60, 100 grand because the value of the property is actually less than what they bought it, like 2 months ago when they signed the deal. So I don't know if those are still going on in terms of appraisals, but because right now it's slow market, like January, February, we don't really do much. So it's hard to say, but like we'll see now coming into March, April, May, and June what happens. So, but just make sure people are properly qualified, like they actually gave them T4s, they gave them information to the mortgage broker so that they know what their proper income is. I find the ones that do have a lot of issues typically are the ones that are self-employed. Those are the ones that typically have a lot of mortgage issues. So when you're dealing with clients that are self-employed, just make sure that they're really properly qualified with their lender, and they've given them the proper T1s and everything that they're supposed to give them T5s.
Like us.
Yeah, like self-employed individuals either pay themselves through a dividend or salary. Most of them usually pay themselves through dividends, and you just want to make sure that they're actually giving this documentation and information to the lender. Someone that makes maybe over $150,000 in their business, but they're only paying themselves $60,000. It's very difficult to qualify for a mortgage at $60,000 these days on a home in the GTA. So, just make sure that they're doing that properly.
Like, are the banks going for appraisals like the last minute or a week before and like 2 months before or something like that?
I don't know when they're actually being done, but I have had a number of deals where a number of appraisals are being done. Meaning that like one came back, wasn't good, they go and hire some other company, they go and do another one. That's like after the third one, they've got some sort of success. So yeah, it's been tough with the mortgage side of things at the moment. So a lot of the common sort of things that we're finding on title that sometimes are people think they're like an issue, but they're not really an issue. You basically take it on as part of the terms of the agreement, is things like registered restrictions, charges, liens, encumbrances. So these are things that, like, restrictions, for example, are things that the city wants registered on title because they forced the builder at the time when they built the project to restrict how the property can be built or what can be used on the property or what can be done with it. So like it'll say like you can't have, like in subdivisions, you can't have a boat parked on your driveway, like things like that. And so like someone will look at it and be like, well, I have a boat. I want to park my boat on the driveway. I don't want to buy this home anymore. It's like, well, did you tell anybody that? Like, if no one knows that you have a boat and that's the only reason why you bought this home, because it has a driveway and you can park your boat on it. You can't just walk away from the deal if nobody knows about it. But if you like made it conditional or like you reviewed your due diligence and stuff like that, and you've told an agent, hey, I'm buying this home because I want to put my boat there. Well, like, you could potentially get sued because you didn't ask the right questions. So like always when you're buying homes in a subdivision specifically, like the newer subdivisions, just like in your intake forms when you're doing your intake with the clients, like just have like extra questions in there. It might sound silly, but they're important. You know, like, do you plan on developing the home? You know, if you know you're working with a developer, do you plan on developing the home? So that you can then reach out to a lawyer and say, like, well, maybe we should do a title search in advance to make sure there's no restrictions on building a certain type of home. Or maybe there's an easement on the property. It's not on there, but easements is another one. There's a lot of easements. So like we had a home in Etobicoke, somewhere around here actually. I don't know where the power lines are. The lines are this way, I think. It was backing onto the power line, and there was a 20-foot wide easement on the side of the house, all from the front to the back. And the guy basically was a developer. He wanted to knock the bungalow down, build a new home. Couldn't do it because the hydro company owned that easement, and they needed to get access to their power lines in the back. And so the guy couldn't build his home. Ended up suing us, the realtor, buyer, like the seller, like everybody. It's still going on. But, you know, in a scenario like that, it's kind of, did you tell anybody that you wanted to build a home? Like if no one knew that you were going to build a home and no one knew that you're a developer or builder, I mean, you're kind of on your own here in the sense that you can't refuse to close. But if there's been an indication that, you know, that is the case, then, you know, I might, as a buyer, go after my realtor for not telling me that I should go and do like a due diligence clause about whether I can build a home. So like putting a conditional clause in the agreement to confirm I can do what I want to do. So it's always nice to ask clients extra questions in your intake form just to make sure that you're protecting yourself. And it's not a scenario where now this guy's trying to walk away from the deal or creating problems in terms of closing. Then we got to try and figure out how to like argue it on our end, whether on the buyer side or on the seller side. So those are, you know, just kind of like a tidbit, you know, just to create an intake form. I think there's Oria's got a form, I think it's 800. It's like an intake form for sellers. Is it 800?
Yeah, there's like a residential buyer checklist and seller checklist.
Yeah. So like take that. I was going to take that, brand it for your own brand if you have brands, and then add to it some extras because it's not necessarily fully detailed. Like, you know, do easements matter to you? You know, yes or no? And then reach out to us and be like, hey, like I did a geo warehouse. It says something about an easement on it. Like, should we look into this? You know, this guy's a builder, a developer. It really matters when someone's a builder or developer. That's when it really matters because their whole point is to knock this place down and build it. And if you can't because there's an easement on it, then.
But usually someone wants to build a house. We had a case, we saw the house in Royal York, and they wanted to build a house. So they were doing due diligence already. How big is the house they can build?
Yeah,
you know,
and that's fine because
just-
he's not going to come back and sue you because
But you
you're
do
already
this one.
in discussions with them and they've like done their own due
Yeah.
diligence. But it's not a bad idea just to add it in there and be like, hey, did you do your due diligence and have it in writing? Yes, I've done my due diligence. I know that I can build this home. You know, and then there's things like that run with the land. You can't do anything about these. These are municipal agreements, utility agreements, drainage, sewers. You know, these are typical things you find in subdivisions that there's nothing you can do about them. They're there, and you just gotta buy the house with it. And that's in the clause 8 of the agreement, I think, or clause 10, one of those title search clauses. And then so the serious ones, and these are the ones that cause problems. We're gonna go through a case example on this one. Is the work orders deficiency notices. Previously, I said that with this clause, it's very important that we to keep it out of agreements because we then have a positive obligation to do the searches, and then it creates problems if something does come up and we didn't really mean it to come up because title insurance covers it. I've had discussions with my title insurance company that we usually refer to FCT, who've basically confirmed that in a scenario where you have this clause in the agreement that their seller represents there's no work orders and things, unless you know that construction renovations was done and there's a clause in the agreement that says the seller agrees to close those permits prior to closing, and there's like a knowledge that one exists and everyone knows about it, buyer, seller, you know, it's been disclosed. As long as that doesn't exist and there's no knowledge that a building permit or an open building permit or a work order, or fire work order, any of these sorts of things exists, then they will provide coverage to the buyer if it's discovered after closing. Okay, so So if you're acting for a buyer, it's now, this is why I do this presentation again. Good to have this clause in the agreement. It also doesn't matter if it's in the agreement or not, because title insurance will still step in and deal with any open building permits or work orders that exist or that are discovered after closing. Okay. The only time where they won't cover it is if both buyer and seller knew about it and it was disclosed, and then it had to be dealt with prior to closing. So open building permits are a pretty serious thing in real estate. Fire work orders, regular work orders, and building permits. Those are the three main ones typically. Deficiency notices are not work orders, deficiency notices. So they're considered a root of title issue, giving the buyer the ability to walk away from a deal, terminate the agreement unilaterally, and get their deposits back if the seller is not willing to fix them. And so what happens is if you, what we were doing previously is we were going and doing these searches and then like killing deals essentially because sellers weren't willing to do it. And we had no choice because buyers weren't willing to take it on either. And then the deal falls apart and it just dies. And now title insurance companies have confirmed that if this clause is in the agreement and nobody knows anything about it, and it is discovered after the fact, we will still provide coverage to the buyer to fix it. So they step in afterwards and they'll fix whatever the issue is. So let's say a seller, we had this scenario recently, a seller put a railing, did a renovation in the home basically, and they got a building, they didn't get a building permit, but they put a railing on the garage on top and they created like a patio or some sort on the front of the house, which is kind of weird, but like that's what they did. Coming out of like one of the bedrooms, and the railing wasn't like, it was the what are they called? Pickets weren't vertical, they were horizontal. So it was dangerous because a kid can climb up and basically fall over. And so I guess a city bylaw officer, they drive around the neighborhoods all the time and they saw this and was like, this is ridiculous, and like issued a deficiency notice against this homeowner. The seller just kept quiet, never said anything to anybody. And then our client discovered about it after closing when they followed up and was like, hey, like, when is this getting done? And basically was forced to do it. They ended up doing the work to fix it. I think it cost them like 10 grand in new railings. And the title insurance company stepped in and did the work, paid them, compensated them for the work. But let's say you knew about that prior to closing. Agent reaches out to the other agent and tells you about it, and it's like, hey, we just got this work order, right? It gets disclosed to the buyer. Now it has to get fixed prior to closing because title insurance won't step in and deal with it anymore because now it's knowledge that everyone knows about. And this clause helps because it says if it is open, the seller is required to close it. And if they don't close it, you can then pursue them in court or not closing it if you want to take it on yourself to do yourself, because maybe it's something minor, it's not a big deal. Sometimes we don't know what it is, right? Like sometimes if the whole house has been renovated and there's outstanding building permits, and then do something properly and you got to open up all the drywall and refix some sort of like LVL because they removed the wall from the thing and it's going to cost another like, you know, 50, 60 grand to fix. I mean, that's pretty serious amount at that point, right? Maybe as a buyer, you don't want to take on that scenario. And that's the scenario where it gives you the ability to walk away from the deal because now that's considered a root of title issue. Or back to what I was saying earlier, hold back chicken, hold back some money. Hopefully someone's willing to hold back some money to do the work. So that's an interesting kind of shift in it. Another one is they can't insure the home for some reason. We've had one or two scenarios where they can't insure. It was more of like a multi-unit property. They couldn't insure the home. Very rare that happens, but sometimes there's just maybe a delay in getting the insurance. That sometimes causes a delay in closing as well. And then the biggest one that I'm finding these days is, I guess, people are trying to unload their rental properties and the tenants are still in the property and they're not leaving. That's the biggest one that I have. I've had 3 deals fall apart on me because of it, because the tenant just won't leave, even though they're supposed to leave. Like you've given them the proper notices, like everything's like documented. You've like potentially even started of an eviction claim in the landlord tenant board, but they're still not leaving, right? They're just like sticking around. They're like really holding their ground. Buyer's not going to move into the property. They're not going to close the deal knowing they got to deal with the tenant, a troublesome one at that, right? So they're just going to like walk away from the transaction. And so just make sure that if you do list a home that it's vacant, you're not listing a home with tenants in it and thinking that this like N12 or 11 or whatever it is that the buyer's going to move into it is going to work. Yeah, it works sometimes if the tenant's cooperative, but like the ones that I'm seeing lately, they're not cooperative tenants and they're not leaving. And this whole thing about cash for keys that everyone keeps talking about is also not working. I had one deal that just closed last month that was supposed to close in October. It was a triplex. It was a family, 2 brothers with their kids, and the parents were supposed to each take a unit. They kicked out all the tenants except for one, and they refused to close the deal because they need the whole thing vacant. And the deal fell apart. We put them in default, and the seller continued on trying to get the guy evicted. Ultimately got the guy evicted, and we revived the agreement like 3 months later with a $50,000 credit to the buyer, based on that. So yeah, so that was like a successful closing, but it took like 5 months to get it closed. So just kind of keep that in mind. Okay, so this clause about the remedies, where I've told you where like where a seller is unwilling or unable to satisfy or obtain, typically gives us the ability as buyers to walk away from the deal. But and that's usually how we use it. We use this. This is the clause in OREA. It's 10 in residential deals, and I don't know what it is in condos. It doesn't really matter so much in condos. More only residential that you're going to have this issue. I think it's clause 10. So typically it's used by buyers to walk away from a deal because there's an open building permit and the seller's not going to close it. That's how I've always used it. We've been like, hey, like this is our right, and based on case law, this is a root of title issue. There's a building permit open. We're not closing this deal. And most sellers in the current market's like, oh man, no, we got to close this deal. Okay, we got to do something. So they'll agree to hold back, or they'll like extend the deal. They'll like negotiate with you. They'll try and figure out a way to get this deal closed because they don't want to go back on the market. Until last week. But basically the way it works is, so sellers unwilling to remove remedy or obtain insurance, so they can potentially get title insurance as well over the issue. If they can, then that's great. In favor of the buyer, this agreement, notwithstanding any blah, 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 shall be at an end and all monies shall be returned. And then it also adds this little bit here, which I always thought was I never really thought about it because we always use it for the benefit of a buyer, but basically it says the seller, listing, brokerage, cooperating brokerage shall not be liable for any costs or damages. Who cares about the brokerages? Like the seller is not liable for any damage, which I was like, that's crazy talk. So the scenario that happened is basically we had a buyer who purchased a duplex. It was represented in that clause that it can be legally continued as a duplex. So in section 10, or not section 10, sorry, in section 8, where the title search date is, there's a little blank line, and you have to put in what the property currently is, its current use, and it can be lawfully continued as that use. And most people put single family residence, or like, I hate the word residence, but like you should kind of detail what it is single family, triplex, if you don't know, then it's great to use residence because you don't know.
Blank?
Huh?
Or just leave it blank?
No, blank's just not no. But something. Like at least put residence, like family residence, something. Or like residential, not commercial, like something. But so these people put in duplex, is going to be legally represented as duplex, right? So we have this legal duplex we're buying. That's what we all know, that this is what we're buying. And then we find out that there's this fire work order to comply with the duplex. Basically, what happened was there was no like fire door, there was no fire separations that needed to be done, and all that sort of stuff. Fire marshal came in, most likely because the tenant was being kicked out, because it was one of these scenarios that was tenanted and they had to kick them out because they wanted the whole home. Could have been a neighbor, like who knows? Someone told the fire marshal to come in and do an inspection on this place, and they did. And they basically slapped this homeowner with this work order to fix and comply to make it a duplex, a legal duplex. And so buyer and seller, they like had their own chats to figure out how to fix this, and they decided that they realized that the buyer is going to be using this entire home for themselves. They had no intentions of using it as a duplex anyways. So they were going to convert it back to a single family home. That required them to basically rejig the layout a little bit, and they had to put the old staircase that the guy had taken out to make it into a duplex, they had to put back in. So they had to do some like structural work basically, and it was going to cost them about $20,000 to do this work. So that was that part. And basically the seller then realized they couldn't fix it in time. I think it was like 4 weeks out from closing, and they realized they couldn't fix it in time. And I find out afterwards that the seller basically sold this property about $120,000 below market value because of the tenant. They couldn't get rid of this tenant. And so they were like, okay, let's just sell it for a really good price. Someone will buy it and then we'll deal with the tenant later. So they sold it at a really good price. And then the tenant leaves randomly, just like left on his own. He was just like, I'm going to leave. Right before closing, it was like a day before closing, just decided to leave because we were like, okay, if they don't fix this, we're going to use the whole tenant vacant possession argument that we're not going to close the deal and force them to like give our deposits back and then sue them for damages and all that sort of stuff. And then all of a sudden on the day of closing, the seller's lawyer sends us an email basically being like, our clients are using clause 10 and that we are not willing to rectify this fire code issue. And we've given you vacant possession. And if your buyer is not willing to waive the requirement of us to fix this work order prior to closing, then we're terminating the agreement under clause 10 and walking away from this deal. So this is the part that they basically this part here, which buyer will not waive. And which the buyer will not waive, then this agreement becomes null and void.
This is all pre-printed.
Pre-printed in the OREA form, yeah. So they were like, well, if you're not willing to waive this requirement of me fixing this and dealing with this, and I can't fix it, I'm not willing to do it either, then I'm terminating the agreement and I'm not liable anymore for anything. And here's your deposits. And I was like, oh, wow. That was not expected in this market. Like in the seller's market, absolutely, always expected because they want to get out of a deal so they can sell it to someone else for a higher price. But in a buyer's market, I had no intentions of this clause ever being used against me.
You mean because the tenant is
Well,
gone?
it was the tenant left. Yeah, that's why.
The house for sale.
Yeah. So now they're looking at it as like, I got my tenant out. I sold it for $100,000 less. I'm killing this deal. I'm putting it back on the market. And I was like, wow, okay, who would have known that this would have happened in this market these days, right? But it was a very, obviously, like everything lined up for them properly. And, from a seller's perspective, he had a great lawyer that like was able to review the agreement and understand what had to happen. And I find a lot of lawyers these days in our field, in real estate, do all sorts of other things and don't really practice real estate and may not remember about clause 10 in the agreement and what it could mean for a seller, for example, or what it could mean for a buyer. On my end, I knew about it, but I didn't know that it was sold for $100,000 less. I only found out afterwards. No one told me. The client didn't tell me. The realtor didn't tell me. No one told me that this property, they really wanted it because it's a great deal. No one mentioned that. And that was very important because I would have known exactly what they're going to do if I had been told that a week earlier. We wasted a week arguing over something that I knew what was going to happen in the end. Had someone just told me that this guy was most likely going to walk because he's going to relist it at $100,000 more. It feels like 20 grand or 30 grand or 50 grand, maybe it was a different scenario at that point, but like
And
100,
what happened?
sorry,
At the end, what happened?
deal died and the seller relisted.
Also, the buyer, like, would it?
Oh, sorry, in this scenario, sorry, yes. In this scenario, yes, I apologize. Our buyer ended up taking on the work for the work order to fix it and forced them to close because he was like, look, I'm getting this property for 100 grand, maybe more undervalue, and I'm gonna spend maybe 20 grand to fix this myself. I'll just fix it myself. I'll do the work and do it myself afterwards. And that was a tricky closing though, because we ended up having to get title insurance to still provide coverage limited to this issue. So they carved out anything related to this issue from the title insurance policy. And I also had to get approval from the lender because I am also representing the lender as a borrower's lawyer. We also represent the lender. So I had to get approval from Scotia, I think it was Scotiabank, to allow the deal to close as well, knowing that this work order was still outstanding and existing. And in order to do that, we had to get an undertaking from the client that they promised to the lender that they'll fix it within 90 days or whatever it was. But we had a good underwriter that was willing to work with us. If you have an underwriter that's not willing to work with you and just like doesn't understand these sort of things, like I mean, some of these underwriters are like 20 years old that like have no clue what they're doing. You know, that was also helpful because that could have also caused a delay in getting the mortgage broker involved with the lender, the underwriters, and all that sort of stuff to try and make sure that they understand that, you know, this is only a $20,000 issue. It doesn't necessarily affect your values. I think they probably look at their like ratios to make sure that they can actually afford this work. They're not like maxed out on their ratios. So it kind of worked out in the end. But you know, it might have not. It might have been a situation where the buyer is not willing to do it or can't do it, doesn't have the money to do it, and has to walk away from the deal because the seller was willing to list it for a higher price. Yeah. And these scenarios will start to get used in the future when the market starts to go back up and sellers know that they can get a higher price for the property if there's work orders or other deficiencies on the property.
There's one thing I don't understand because I understand officially this was in the registry office registered as a duplex, yes?
Well, it wouldn't be in the registry office, it's just like considered a legal duplex. So in order for something to be considered a multiplex, like a multi-unit property of some kind, there's 4 pillars. I call them the 4 pillars. I don't know what legal words for this is, but there's 4 pillars. The building code, or sorry, let's start with zoning. Zoning has to comply. So you have to have zoning needs to allow for the number of units that you're buying. The building code has to be complied. So, you know, it was built to spec a 2, 3, 4 unit building. The electrical authority, the electrical code has to comply, and the fire marshal has to go in and do an inspection and make sure that the fire code. So all those are the 4 pillars to a multi-unit. As lawyers, we can only confirm zoning, and that's it. I can't tell you if the building code complies. I can't tell you if the fire code complies, and I can't tell you if the ESA code complies. Those are all due diligences that a client has to do on their own. And those are usually things that you find in a commercial deal where you have a 6-month conditional period because there are various city inspectors that go in and do their own inspections and the seller signs an acknowledgement and authorization allowing that to happen. You know, in a residential deal, that never happens because you're closing in 90 days, right? So you don't have the ability to go and organize with the city and inspector to go in and tell you if this multi-unit complies with the code. So I would imagine most properties in Ontario have never been inspected for a triplex or fourplex in the city or duplex in the city. And that's why a lot of these municipalities right now are creating these registries. Like I think in Oshawa or Pickering, one of these cities, they have a registry where if you have a 2-unit, 3-unit, or a 4-unit building, it has to get registered on their system, and I can go and look to see if it's registered in their system as a multi-unit. And they go through that process in order to get their application approved. They go through a whole building inspection, a fire inspection, and an ESA inspection.
Because I thought you cannot simply say there's a duplex if you don't have all those approvals, yes, that everything is in accordance.
Anyone can say anything.
That's
the problem with the
legal
law.
representation. So who said that? There's a
Clause 8.
duplex.
It's in clause 8 in that blank where it says the property can lawfully be continued as duplex.
Oh, okay.
And they wrote it in as a duplex. So we rely on that. That's a representation. That says that you're telling me that you're selling me a legal duplex. That's what that means. But me as a lawyer, I can't confirm that. The only thing I can confirm is zoning. I can do a search with the city and ask them, what is the zoning for this property? How many units are permitted? 3? Great. But
they-
beyond that, we tell clients, we can't confirm anything for you, because some clients will come back and be like, hey, I want to make sure this is legal. I'm like, should have done that on the conditional period, but you're not gonna be able to, because, and then they go back and they ask the realtor, hey, why don't you tell me about this? Now I don't know if my property is legal.
So if you
Um,
represent the buyer, you would advise them that before, the buying this, you should ask for inspection, like to see whether everything is,
Yes, yes.
comply. You
But
want to buy duplex.
But it's not practical, right? Because when you're buying a triplex or duplex in a residential market that's closing in 60 days, 90 days, you don't have time to go and do those inspections,
Yeah.
right? You can't. You just have to tell them. You have to tell them, like, we're buying this property. They're telling us that it's representing as a legal duplex or triplex. We can ask to put conditional clauses for you to do your own due diligence, but then you got to go and hire like someone to help you out with that. I can't help you out with that. You got to hire someone. I don't know if this deal's going to go through if we do that.
Can they come back to us later if they find it not like legal after it closes?
No, because you have it in writing that you've had that discussion with them, and you have it in writing. Presumably you get it in an email or something that says, like, we've discussed that I can't confirm for you if this is legal. You've rejected putting a conditional due diligence clause in the agreement to confirm that it's legal. And that should kind of protect you from the client in that sense.
Conditional on the seller providing evidence that they comply.
They never do. They never do.
Unless the seller
That's-
has already done.
Yeah.
And has a document showing that. it's-
Some like so the only place where that matters is where a municipality has a registry system for a duplex triplex. Otherwise, like if you're buying in Toronto, Toronto doesn't have one, for example. London has one. I think Pickering or Oshawa have one.
What about the legal non-conforming?
So that's different. Legal non-conforming basically means that it was legal, let's say 1970, and it's no longer legal now based on the new zoning requirements. Nothing to do with the building, nothing to do with electrical, nothing to do with fire. It's only about zoning. That, like, back in 1970, 4 units were allowed, and now in 2026, only 2 units are allowed. As long as it continued its use as 4 units throughout time, never went down a unit throughout time, then it's a legal non-conforming property. So it was legal back then, not legal today, still legal today because the zoning allowed for it back then. That's what legal non-conforming is, but it's just around zoning. Yeah. Okay. So that was a fun one. I like giving you guys examples of stuff because, like, otherwise reading stuff out is just boring. And I get to experience a lot of these weird things that I never think that would happen to me. More sort of common problems that don't really cause problems in the sense that deals not going to close, they'll still close, but there's a lot of arguments around it. Is fixtures versus chattels, rental items, and we'll go through that in a second. So fixtures, chattels, I always like to tell people and give this as an example to realtors is imagine you have a dollhouse. You take that dollhouse and you flip it upside down and you shake it. Whatever falls is a chattel and whatever doesn't fall is a fixture, right? That's basically a good example. So imagine you're the buyer, or sorry, the seller, and you have a picture hung mirror in the bathroom, right? I don't know if you've ever seen these. They're not like fixed they're not like glued onto the wall. They're like just like a picture frame. And they're like, just the way a picture frame hangs with a nail behind it, and that's it. I mean, technically, a seller can take that and take it home with them wherever they want, and you don't get it. So we get a lot of those scenarios where people come back and like, hey, the bathroom mirrors are gone. And it's like, how were they hung? Just the way they took all their other paintings in the house, they're going to take that one as well, right? So kind of go through that with them, and then as you're going through the home, if you see certain things that like could be a risk, and you want those specifically, add them into the chattel section. Like, I want this chattel, whatever it is, right? Be very specific about chattels. I always say, like, I find a lot of agents, they're lazy and they just put like a stove, fridge, dishwasher. Well, no, like put current existing stainless steel Frigidaire dishwasher, like put in some extra details. I've seen some agents do fantastic jobs with it where they actually go and like take photos when they're there of the serial numbers of each and every individual appliance and then add it as a Schedule A clause. And basically they put like see Schedule A on the chattel section, and then in the Schedule A, they like detail it out with the serial numbers so that you know that that's the one that you're gonna get. They're not gonna replace it with another Frigidaire stainless steel because they can. I had that happen to me. I bought a condo many, many moons ago, and it was a Fisker Paykel fridge or whatever it was, and I get there the day of closing, and it's like a GE fridge.
Yeah.
I was like, where the hell did the fiscal one go? So, you know, like be sort of detailed when it comes to that sort of stuff.
But if you don't have this clause, then you cannot do anything, yeah, like.
Yeah, if something's not listed as a chattel and they took it, and it's theirs. Yeah.
So the phrase, probably.
Yeah. Fixtures, you know, I forgot what it was. Someone took some of the weirdest thing once. It was like an AC unit or something, and I was like, no, that's a fixture. Like you can't just take that. So you know, so sometimes they cause problems, but it's very minor, and usually no one refuses to close because of it. Usually we get involved and we're like, hey, look, we're going to charge you $500 an hour to argue this issue. So either you like close or pay me $500 an hour. Like you're better off just buying yourself a dishwasher for $600. Like no point in paying me $500. So that's kind of usually how we resolve those kind of issues. Rental items, these are very important. What I was talking about, you know, that form 800 with like your intake when you're listing a home for a seller. Make sure you're asking about rental items. You know, a lot of agents forget to ask about rental items, and you know, it's discovered that the hot water tank is rented. You know, and then they're like, hey, why didn't you tell me about this? Like I could have put it in the agreement and I didn't have to buy it out now because they have to like buy out the rental contract because it's not in the agreement as something that's being assumed by the buyer. Okay, so just in your intake form. And if a client lies to you, then they'll be like, hey, look, you told me it's not. Like this is your problem now. It's like you signed this form that said it's not included, you know? I'm not paying for it. You pay for it. So, because a lot of these type of things, clients come back to the realtors. They point the finger at the realtors and be like, well, like you cost me $2,000 on closing. I want 2,000 from your commission because you guys make 30 grand on my commissions. Like well, the 30 grand got split with another guy, but okay. And then there's also like 20% going to brokerage. You know, like people don't look at it that way. They look at it as like this person just made 40 grand. It's like, no, there's like a lot of other people that got money along the way, not just me, 40 grand. So, you know, protect yourself basically there. And then these are just sort of after closing problems. You know, property wasn't cleaned properly. You know, there's garbage everywhere. Again, I usually step in and say my hourly rate's $500 to argue this with the seller. Go and hire 1-800-GOT-JUNK and deal with it on your own. Buyer beware scenarios where someone thought that something was supposed to be a specific way, but they never had a conditional clause to review it and inspect it prior to closing. So again, general rule is buyer beware. You get the property the way it is. And if there's something that's like going to break in 2 months, then it's going to break in 2 months. It is what it is. That's how you get it. It's an as-is property purchase if there's no other clause in the agreement that says you're going to do some due diligence. It's always as is otherwise. Latent defects. So these are, you know, things like holes in the walls where the paintings used to stay. Those don't get repaired. Those stay the way they are, you know, but if they like had this big massive hole and you see the bricks on the other side, and it was hidden behind a painting, well, that's called a patent defect at that point. So now that's a little bit more of a different scenario where like you as a seller purposely hid this from me and I only discovered it after I moved in and moved things away from the walls and stuff like that, right? Very hard to prove that a seller is trying to deceive you though. I haven't really had a lot of scenarios in that where we've been like successful to prove that someone deceived someone. That's the kind of the rule. You got to prove that the seller deceived you in buying this defective property. Suing, we'll go through that in a second, small claims in Superior Court, and then unpaid tax utilities. We get tons of these. Like, I mean, I don't know what's wrong with people. People are not paying their taxes these days. But title insurance steps in and deals with these ones. So after closing, if there's unpaid property taxes, the buyers will file a claim with title insurance company and they step in and pay them, compensate them, and they usually pursue the seller in court, in small claims court, for recovery. Sometimes they sell it off to a credit agency, like those debt collectors. And then, do I have time? Am I like,
But it's gonna be
yeah,
the
I gotta go for
the
the 2
buyer's
minutes.
lawyer find out that there are unpaid taxes or something, and then simply withdraw the money from the closing, money from.
If you find in
And-
advance of closing, we can negotiate that payment, yeah.
Well,
There's
but
a
that's
requirement.
why we have it due like 2 weeks before you take the title search and all those things.
Well, we don't search, so we only search title. Property taxes are things that the municipality has on record. We don't search municipal records. We only search what the ministry has, which is the government of Ontario, which is title based. Taxes don't relate to title. Those are two different things.
We as
Yeah,
suppose,
yeah.
but
This is why we get title insurance to cover it. A lot of people say, well, why didn't you, like, title, the cities will say, why didn't you order a tax certificate? We could have told you in advance of closing that there's outstanding taxes. The tax certificate costs anywhere between $100 and $200 to order from the city. Title insurance costs on a $600,000 house, $500, and it already has the coverage. So why am I spending another $200 for something I already have coverage for? Right? So that's why we don't do them. Okay, so suing. After closing, you have two options basically, which is small claims court. There's a $50,000 limitation on that. Anything under 50,000, you can sue in small claims court. And usually you go on your own, maybe get a paralegal to assist you. Otherwise, you can go to Superior Court. That's over 50,000, and that's where we usually recommend a lawyer. Yeah. That's where we usually recommend a lawyer, because it's sort of like the big boy court and judges with the fancy hats and stuff. So, you know, there's a very strict process on how to do things. So you want to make sure that you're hiring a lawyer, and it's got to make financial sense, really, right? Like if you've got a $52,000 issue, like don't go to Superior Court for that, because you're going to spend $40,000 on a lawyer or $30,000 on a lawyer. There's no point. But, you know, I always say anything like 100 plus typically might be worth hiring a lawyer to sue or whatever the damages are. You don't necessarily get to recover your costs. So you can sue for costs, and if you're successful, they pay your lawyer fees, but they don't pay all of your lawyer fees. They only pay a portion of your lawyer fees. And it's like sometimes max 50% of the lawyer fees. Right. So, you know, if you're going to be spending $30,000 on a case, you might get 15 back, 15 still out of pocket for you. Right. So those are the two ways that what happens after closing small claims court. That's it. And questions? No? Yeah. Are you guys finding a lot of deals closing, not closing, or having issues? I deal with it every day.
Well, it's hard to do deals with this, but
Yeah,
you just hope they close.
I know. It's I've got every single week there's someone needing an extension for whatever reason. I had a deal this week actually that we're trying. I'm still haven't heard back from them, but basically our client's selling. The buyers picked the date, March 16th. They knew that they were relying on the sale of their home to get the equity out of that home in order to buy our client's home, and they picked a date in June for that home. And I just don't even understand like what happened there. I'm not quite sure, like, did the realtor advise them wrong? Did the clients think they were going to get a bridge loan but not get a bridge loan, but knew that they weren't going to get a bridge loan because they told me that they're not going to get a bridge loan? So I just don't know what happened. But anyways, now they're trying to like change the date so that they match up, so that
June?
to
From
June.
March to June?
Yeah. So that the dates can match up. Our client's in a retirement home, like the dad passed away, the mom's like paralyzed, so she has to like she's in a home basically being taken care of, and the son now was relying on that $5,000 a month to pay for the home, and now they don't want to pay the $5,000 a month because they're old people that are buying, and they feel that they like are getting screwed by the buyer of their home. It's like, but you guys chose these dates. It's like, what did you think was going to happen? So, you know, in a scenario like that, the buyer now is out. What is it to June? Like 15 grand, basically, probably around there. for this retirement home that they're not gonna get from the buyers. But yeah, so we're dealing with a lot of weird things these days with extensions and scenarios and situations, and everyone I feel like knows that you don't want to go back on the market, or like, what are you going to do? Go back on the market? That's usually the response that we get from other buyers. So they know that people are being squeezed in that sense, like this on the seller side. Yeah, I had another one that we're just dealing with. There's a lot of them. There's a lot of mortgage issues, not getting mortgages in time. That's a big one I find these days. There's no mortgage, waiting and waiting and waiting, no mortgages.
Is it because they're not getting a pre-approved mortgage? Like, why are we having?
The appraisals are the ones that are causing the problems after the pre-approval, but yes, most of them are also just not getting pre-approved properly from the beginning stage. So like what happens is a lot of people go to a mortgage broker and the mortgage will be like, hey, like, how much money do you make? Like, I make 100 grand. Oh, okay, you're like approved for this. But that's not an approval.
No.
That's just like me going online and asking ChatGPT how much money do I make and how much money, what kind of home can I buy? Like that's literally no different. Mortgage agents that understand how this world works in the purchase and sale side of things, because there's a lot of mortgage agents that work on the refinance side, which is very different than on the purchase and sale side, right? They're not getting the right documents from their clients and submitting them to the lender in advance to get like proper approvals. Yeah, they're still conditional, like, you know, on certain things, but at least the income verification part, the down payment verification part has been completed, and you know that that part isn't going to cause any issues. And maybe the appraisal now is the only thing that you're waiting for.
You said things aren't appraising now?
No, we're getting a lot of pushback on appraisals from clients. Well, I don't know what they're being praised like in terms of how much, but I know that people are having a lot of issues with it in the sense that they're coming to us and saying like, we need an extra 2 weeks because we need to get another appraisal done. Sellers are also being weird about it and be like, well, we don't want another person in the home. I was like, okay, well, the deal's not going to close. I mean, let the bank go in or not. I mean, I don't know what to tell you. Like, you want the deal closed or not? So.
We have a situation here at the office where a deal that happened 15 years ago for construction, right? The builders paid, let's say, 2 out of 3 commissions, and the deals, I guess, they're not closing, so they're asking for, well, they're doing like a clawback. They want
Yeah, they want the money back.
the money back.
Oh, okay.
What, like, have you heard any other situations like that? I mean, are they?
I have
those
not
contracts
actually.
built so that if they don't close.
We've
they
definitely
go
not
back?
closed a lot of new builds, but I don't know what.
I know.
No.
You have to give the money back.
You have to give them money.
Yes, it's in a contract.
In the contract, right?
Yeah.
I guess it all depends. Yeah, I guess it depends on what's in the.
Most builders up back, you have to go back.
There's no way to get around that.
I guess it depends on what you put in your contract with the builder. Yeah, there's a lot of deals that are not closing on the builder side. I can tell you that. I'm dealing with that as well.
And are they really going after the buyer?
Oh yeah,
after?
yeah. I've been hearing a lot of lawsuits about that. Yeah, at one point, like last year, they weren't. Last year they weren't going after them, but this year they are. This year I've been hearing a lot about the builders actually going after. Like last year, there was a point in time where builders were very cooperative. We can get like discounts on occupancy fees. We were able to get, you know, maybe price reductions. There was all sorts of stuff they were willing to work with us on. This year, I'm having a lot of troubles with builders agreeing to anything other than potentially extending the deal with costs. Like, so I've had a number of deals where we moved from November to January and February. You know, to give them enough time to get their money in place and all that sort of stuff. And they've agreed to extend, but the extension fee is like $500 a week, let's say.
$500 a week.
Yeah. So it's been still gotta pay it. But yeah. I only had one deal where I was able to negotiate a mutual release with the builder, and I don't know what that builder was thinking. Like the property was like over $200 and something thousand under value in terms of the appraisals, more, and I think the deposits were only 180,000. It was up in King City. It was like a townhouse project.
So the deposit was greater than
Deposit was less than the value depreciated on the property from the appraisals. So even if they went to go market on it, based on the appraisal values of it, you wouldn't be able to get, unless someone had the extra cash, but that was the only way to, what we did there though is the client was willing to let go of their deposits in exchange for the mutual release so they don't get sued. Because they would have got sued anyways, right? I don't know why the builder agreed to that. It was a weird one. Maybe he wanted the unit for himself or something. It was like a small project, it wasn't like a big one. I find the bigger guys are the ones that are not willing to work with anyone anymore. The way they used to, at least. But yeah. So you had a question, Andy?
Or a situation where the seller doesn't want to release the deposit for the buyer. Let's say you have
Like
three
the,
conditions, like financing, whatever.
oh, and
And
then
then-
you don't waive one of the conditions.
Yeah, and then the seller says, sorry, I'm not gonna sign the release.
Yeah, I had one scenario like that. I don't know what happened to that afterwards though. But yeah, I had one scenario like that. Typically, I find the issue is not from the seller. I find typically the issue is from the brokerage, where the brokerage doesn't want to release the money. And they basically want either a mutual release signed or a mutual release or a court order. But so what I did in that scenario was like the buyer and the seller signed a direction to the brokerage to have the money released to me so that I can then give it to the seller. And the brokerage still not giving us the money. So now it's going to go to court and everyone's going to sue the brokerage to release the money basically. Because both buyer and seller agreed to have the money released to us. The agent still has a contract with the seller for their commissions, because in that scenario it was the buyer that caused the problem. They didn't close the deal. And the seller can pursue, or the listing agent can pursue the seller for his commission still if they want to, because they're still owed that money. They're not, it wasn't the seller's fault for not closing the deal.
No, it's not about closing the deal, it's about the release documents. Let's say you make an offer and you have 2 or 3 conditions.
Yeah, I get what you're saying. In your scenario where the condition wasn't even waived.
Correct.
Yeah.
It means the seller should sign a release to release and the seller doesn't want to sign it.
Yeah.
Because they think the buyer,
Bad faith.
yes.
Yeah, they have a right to do that. They can go and sue in court for bad faith and keep the deposits in trust. It's unfortunate, but the buyers can also equally go to court to have the money released. It's probably about $10,000-$20,000 legal action.
They have to go, depends on they can go to the small claim.
That's why there's court. Like you can't force anyone to do anything. That's why the courts exist. To deal with people's issues. You know, if 2 parties don't meet eye to eye, that's why the court's there for, to tell you how you're going to meet eye to eye. It's unfortunate because it costs money. Yeah. This is where AI is coming in now. They're creating access to justice and legal, yeah. Cheaper access to justice. There's a lot of companies out there that are litigators that are using AI to help reduce legal fees. Harvey is one of them. You guys have heard of it.
Harvey's.
Harvey.
Harvey.
Not Harvey's the burger chain. That's kind of funny because a Canadian company called Harvey, yeah.
The burgers.
Yeah, there's a lot of issues out there. It's becoming harder and harder to do deals. For us, at least. I don't know how it is for you guys. I'm sure it's the same for you guys.
I just feel like I just have to figure out how to protect myself. Like,
Yeah.
that's why I asked the
Yeah.
questions, I'm like, okay, so if this comes up, how do I
And
protect
this
it?
is what happens when you're in a down market, right? Balanced down markets, that's what it creates. When it's in an upward market, there's really not a lot to worry about because everyone's closing and the next person wants to close and just want more. You know, there's no issues there, and the appraisals are going through totally fine. There's no issues with appraisals, and you know, everyone for 15 years, everyone was just like coasting along because everything was just like going along. Nothing was really happening. There wasn't really a lot of issues. It was more about like how do we get the best price for our clients, the highest price, you know, like you maybe had some issues around like bidding wars and things like that. And now it's like, okay, well now everyone's wants to sue the next person if something goes wrong.
sorry, how do I myself, I don't get nobody sued in this.
Yeah, I always say protect yourself first.
Yeah.
There's protect yourself first, worry about the clients after. So
Like,
you set yourself
but
up.
that's why I'm like.
Yeah, protect yourself first, then worry about the clients. Because the clients aren't worried about you. I can tell you that.
Well, no, that's what, definitely, no. That's why I'm like, how do I protect myself, and then how do I like
Yeah.
protect that? So,
You got to protect them, of course. It's part of
Yeah.
your job, but make sure you're doing it so that you're also protected and thinking about yourself. It's the same thing for us. When we're going to a file, we're thinking about ourselves just as much as we're thinking about the client. I'll let you. Is there anything online? I don't even
Any
know.
questions online? Carol, Frank,
They've probably left.
they're on mute.
Disappeared on us, like everyone else online. Cool.
Nothing for me, thank you. That was good. Thanks very much.
Yeah.
Thanks, Carol.
Thank you.